In this recording, rather than looking at law in its entirety, we're going to be looking at the Australian legal system in particular. We're going to start with what we call the reception of British law into Australia. Then we're going to talk about the common law, what that means broadly, and in the very specific uses that we will have. We're also going to look at the area of law known as equity. We're going to look at the systems and structures of the Australian courts, the way the courts operate in terms of being responsive to each other through what we call the Doctrine of precedent. Then we're going to look at legislation and in particular some aspects of statutory interpretation. Finally, we're going to talk about ADR, or alternative dispute resolution, mechanisms and means of resolving disputes without having to go through the court system. So we'll kick it off by talking about the reception of British law into the continent of Australia. When the first fleet arrived in 1788, they founded a penal colony of New South Wales in Botany Bay. Now, one of the really important considerations, and it's kind of plagued Australian legal history, was the fact that when the British, and the British Empire, you appreciate, was a large, extensive conglomerate. When the British went to nations and settled them, importantly, the laws of the local people would be incorporated into the common law of that particular place. And really that sits with the notion of what we call Westphalian sovereignty, that idea that land could be conquered, land could be succeeded through some sort of treaty, or land could be settled when and where nobody was present. Now, this has caused a great deal of difficulty, and some might say trauma, in Australia, because for a very long time the Australian courts refused to recognise the existing Indigenous inhabitants of the continent of Australia. Contrast that with other nations, India, Jamaica, New Zealand, where the British arrived and imported British law onto those places, but still recognised the existing customs, traditions and legal systems of the Indigenous peoples. And it wasn't until the case of Mabo and Queensland No. 2 in 1992 that the Australian High Court recognised that Indigenous Australians had existing laws, customs and traditions, and at that point in time granted what we call a very weak form of land ownership known as native title. Somewhat unfortunately, the word or phrase common law can have different meanings based on the context it's being used in. Perhaps the best way of describing this to non-legal types is to think of common law as a system as being distinct and different from civil law systems, socialist law systems, and religious law systems. For example, Australia, New Zealand, the United Kingdom, and the United States use a common law system, largely because the British went to these nations and the law was received there, and the style and structure of that legal system gives judges the opportunity and I guess the power to make, adapt and refine the law in those places. And so when we talk about a common law country, we're really meaning that list of around about a fifth of all legal systems, nations with legal systems in the world. The second way that we use the term common law is what's called a source of law. Judges do from time to time make law and refine it and give judgments, and those judgments bind lower courts or courts lower in the hierarchy. Now, when lawyers and judges are referring to rules, they can refer to rules that have been made in cases, so by judges, or they can refer to rules that come or flow from statutes. And so when we're talking about common law rules in that context, we're meaning common law as distinct from legislation. For example, the word possession comes from the High Court. The definition of the word possession, even though that word is used in legislation such as in the Drugs Misuse Act, the definition of the word possession actually flows from a High Court judgment. And so the way that that's described by lawyers and judges is that the definition of the word possession flows from the common law. Now, the third definition of common law is a little bit more opaque, and it requires us to just step back a little in time. Prior to the 1870s, a person who had a grievance, a civil grievance, could go to two different places in order to bring their action. They could go to the courts, and we would call those the courts of common law, and in order to bring that action, it had to be framed in a very clear, carefully prescribed way. If you couldn't prescribe the particular problem in that way because it was something unusual, then you could still bring an action, but you had to do this in what we call chancery. The chancery was a system of or structure that was like the courts, but it was run by priests, and they had developed their own rules in what we call the area known as equity. Now, when we're using this third meaning of the term common law, we're meaning it a set of rules that are distinct from the equitable rules. After 1870, judges in the courts essentially assumed both hats. They fused the two together, and so a person could bring an action in the one physical court system, but a judge, when going and interpreting and making an adjudication or a decision, could use either the common law rules or the equitable rules, or a blend of the two. This particular use comes up when we're discussing contract law, because there are still some components to this day of contract law in our system where we take equitable principles and they will form the basis of how a judge will go about deciding that case. And so in that aspect, we're referring to a common law rule as opposed to an equitable one. And this can be, admittedly, quite confusing to the non-lawyer. So what exactly do courts do? Well, in our system, there's really three main functions. The first is as an adjudicator. When two parties need to resolve a dispute, the court essentially is the arbiter. They are the ones who determines who wins and who loses in our adversarial system. And again, this can be either in the criminal sphere, where the Crown, which can be the police in Queensland for low-level criminal matters, or the Director of Public Prosecutions for the more serious crimes, when they bring the action and have to prove all of the elements of a crime beyond reasonable doubt. And the court acts as this impartial arbiter in that situation. In the case of civil disputes, the parties collect all of their evidence and they trot up to court, and the judge will determine one way or the other who wins and who loses. The second aspect of the courts is their enforcement function. What does that mean? It means that courts make orders, and those orders have force. A court can make an order that a person, for example, pays a sum of money. When a civil matter goes to trial, one side wins, one side loses. The loser usually has to pay the winner some money. And the court has the power, this inherent power, to construct these orders. The judge can write the order out, sign it off, and the party who wins can ask enforcement agencies to actually go and carry out the will of the court. The third aspect of courts in our system is what's called this lawmaking function. Now, we have already explained that there is such a thing as judge-made law. Judges, however, in our system don't usually take it upon themselves to just create law on the fly. Instead, what they do is they look at existing judgments and the reasons for those judgments that various judges have made before them, and they essentially map the law out to maintain the internal consistency of the entire system. What does that mean? It means that when the law in statute or when the law from previously decided cases is absolutely crystal clear, judges don't really make law at all. They're just essentially following the instructions that they've already been given. It's only in situation where things fall between the cracks, where Parliament and drafting legislation haven't quite got it right, or they've forgotten something, or all of the previously decided cases with similar subject matter don't quite align with the facts of the case at hand. It's in that situation where judges in the common law systems do have to construct law on the fly in order to really fulfill their function in our system. When we think about the types of matters that come before our courts, these really fall into two broad areas. We have criminal matters, where the state, the nation state of Queensland or the Commonwealth of Australia, is bringing the action against the person. The other type is civil matters, and that's where citizens are either trying to resolve things amongst themselves, or a citizen is actually bringing an action against the state. If we look at the first of these, we've got to appreciate that the criminal law, first of all, is not about the citizen. It's actually not about the individual, and it's not about the victim of the crime. It is about the state demonstrating through bringing this action that the behavior of this person is reprehensible, it's not acceptable, and that this person needs to be punished, both because society is outraged, but also for other reasons, such as the need to deter others, or to rehabilitate the offender, or to protect society by incarcerating that particular person. Criminal matters need to be contrasted from civil matters that, in most situations, is where one citizen is bringing a matter against another. For example, a person, we'll call them the plaintiff, brings an action against some other person who may have breached a contract. We refer to that second person as the defendant. In that situation, the court acts as an arbiter of this particular matter and will decide one way or the other. The person bringing the action will either succeed or she or he will fail. And usually the result is money. Money is the default remedy for civil actions in our system. Another aspect, though, of civil law is where the citizen can bring an action against the state themselves. Now, one component of this is this area known as administrative law and administrative review, which doesn't really fall very much in the business law sphere of things. It's when the citizen asks the court to make a government officer or government department do a decision properly. For example, if a particular citizen is not granted a license for an activity that she or he had applied for, that government department has certain rules that they need to follow in order to reach that decision. If they don't follow those properly, the citizen can ask the courts to change that decision. It's a very powerful avenue that a lot of people aren't particularly aware of but doesn't really fall within the scope of what we're going to talk about throughout this particular subject. So the court system is hierarchical. What does that mean? It means that there's a top and there's a bottom, and the decisions of courts further up in the hierarchy bind those below it. Also, if you have a decision made in a court which is lower in the hierarchy, and you don't like that decision, and you think that decision is wrong, you have, in most situations, a right to appeal that decision. Now, the diagram in front of you is kind of pyramid-like. At the very top of our hierarchy in Australia is the High Court. If you don't like a decision of the High Court, too bad, because there's no further right of appeal to go to any other place. However, if you're starting at the bottom, if you don't like a decision, for example, in the Queensland Magistrates Court, for criminal matters, you have the right to have an appeal. And that appeal is lodged and heard in the Queensland District Court. If you don't like that decision, you can then appeal to the Queensland Court of Appeal. And if you don't like that decision, you can go to the High Court. However, there are some restrictions on this, in that you can't always, what they call by right, lodge an appeal. The most important of these is that from decisions in the full federal court, the full family court, or any of the state courts of appeal, you can't by right go to the High Court. You have to do this process known as leave. Seeking leave is where you trot up, usually in front of between 1 and 3 High Court judges, and you do a preliminary hearing where you set out what your argument's likely to be, and most importantly, you're setting out why this is of such importance that it needs to be heard by the High Court. You have to actually persuade them that your matter is sufficiently important to go to the High Court. And appreciate that there are only 7 High Court judges, and they are the ultimate arbiters of decisions in all of Australia, a country with over 20 million people. Some other areas to note are to do with tribunals. Now, tribunals, and on our diagram we have the Queensland Civil and Administrative Tribunal, QCAT, as well as the Federal System Tribunal, which is the Administrative Appeals Tribunal, the AAT. Now, decisions that are heard in tribunals are not made following the same process and procedure as you would expect to find in a court. And most importantly is that the rules of evidence don't apply quite as strictly in these tribunals. As a result, one of the difficulties that citizens who do go through those avenues can find is that you can only sometimes can you lodge an appeal from those tribunals into the court system themselves. And so from a strategic perspective, if you do have a particular dispute and you think that dispute is likely to be resolved on technical legal grounds, it's often advantageous to actually lodge through the courts as opposed to the tribunals, particularly if you feel very confident of winning. Now, one of the benefits, of course, of tribunals is that they're much, much cheaper, both to apply for and to have your matter heard in, and in the case of QCAT, you can go without a lawyer. In fact, if you do go to the tribunal, and the other side wants to have a lawyer, they have to ask you first. So it can be quite a powerful mechanism to have small matters heard in the tribunal system, particularly if you don't want this very, very cumbersome, very technical and structured system that our rules of evidence make up. In terms of what we call the original jurisdiction of courts, that's where when you first want to have your matter heard, you go to the court most appropriate for that matter to be heard in. In Queensland, if you have a dispute, and that dispute in terms of money is unlikely to go beyond $150,000, you can lodge this in the Magistrates Court. The Magistrates Court will be heard by a single judge, referred to as a magistrate, but this is a court, and if a matter does go to trial in Magistrates Court, it will follow all of the same rules of procedure and evidence that one would expect in the other courts in the Queensland system. It's important to note that Magistrates Court has no appellate jurisdiction. In other words, you're not ever appealing to the Magistrates Courts from anywhere. It's really at the bottom of the hierarchy. If your civil matter is likely to have a dollar amount associated with it, so the amount that you'd be seeking is more than $150,000 but less than $750,000, then you can apply to the District Court. Reasons that you would do this? Well, first of all, the Magistrates Court only has the power to award up to $150,000. But applying to the District Court has noticeably larger fees. Now, the District Court does also have an appellate jurisdiction for civil matters, and what we call the jurisdiction for them to do that is that if the award in the Magistrates Court was more than $25,000 and less than $150,000, you can just by right apply to the District Court. You can fill in a form, pay the fee, and appeal to your matter from the Magistrates Court to the District Court. Now, the courts, though, aren't really that happy having to hear matters with lower dollar amounts. And in particular, this $25,000 rule. If you have gone to Magistrates Court and the amount that the award was for was less than $25,000, you have to seek leave of the District Court. This is where you have a small special hearing in front of the District Court judge to basically argue the fact that there is a particular reason for this matter to be heard in the District Court. And if that leave is refused, you are stuck with the original order. You can't appeal that further. The Queensland Supreme Court is presided over by a single judge, and it has an unlimited original jurisdiction for civil matters. What does that mean? They can award any amount of dollar values as part of the judgment. Another thing to note is that you don't appeal to the Supreme Court from anywhere. In fact, the place where you would appeal decisions from either the District or Supreme Court is what we call the Supreme Court of Appeal, or just the Court of Appeal. That is where 3 judges, who are themselves Supreme Court judges, will sit and hear the matter together. You can't apply to go to the Court of Appeal straight away. In other words, it has no original jurisdiction. It will hear appeals from single judges of the Supreme Court or from the District Court, but for the latter, if the amount is small, less than $150,000, you have to go through this leave process where you argue your case in a preliminary hearing before you're allowed to actually lodge the full appeal. Finally, in Queensland, up to 2009, Queensland had many tribunals where matters could be heard of small dollar amounts, or if they concerned a particular area of law. In 2009, Queensland merged all of these into one tribunal, the Queensland Civil and Administrative Tribunal, or QCAT. Now, QCAT can hear disputes, but only of a particular type. Now, importantly for those that are in business, QCAT has the power to either hear what we call liquidated debt disputes. That is where the amount that the party or the plaintiff is bringing the action for is fixed or set in some way. Usually That's through there being a clearly established dollar amount in a contract. QCAT doesn't have to argue, or you don't have to argue, what the quanta or amount of this particular contract is. If it's already a fixed amount, QCAT can hear decisions, provided that amount is less than $25,000. It can also hear consumer law disputes. Now, consumer law disputes are things that arise where the party bringing the action is a consumer within the definition in the Australian consumer law. Again, it only has jurisdiction to hear matters up to $25,000. But importantly, it can't hear matters between businesses where the amount isn't already fixed. It's not a liquidated debt. QCAT also has jurisdiction to hear matters on a very, very wide variety of other governing pieces of legislation. For example, the main one is residential tenancy disputes. That if you have difficulties with residential tenancy, either you as the tenant or you as the landlord can bring that action into QCAT and have it heard in front of a tribunal in a low-cost, less formal manner than going through the court system. In almost all civil matters that occur in our court system in Queensland, the judge alone will determine the outcome of that particular case. And really, this is two separate and distinct processes carried out by the same person. The first thing is that the judge will determine the facts. The judge will hear evidence from both parties, and where these are in conflict, the judge will prefer one to the other. In the case of, for example, a decision about what two parties agreed an amount to be, where one says that it's $1 value and the other says it's a different dollar value, the judge is going to have to determine under this, as what we call the arbiter of fact, determine, well, who's right and who's wrong, who's telling the truth, who's lying. Or in most situations, if the two parties are in conflict and the judge finds that they're both reasonable, honest people, which one is mistaken? And it's a really important consideration, because the judge, as this arbiter of fact in civil disputes, is usually going to be the last person to look at the facts and determine which story is preferable, or which is to be believed, or which is more reasonable. The reason for that is that issues of fact can't be appealed in most circumstances. Now, in the criminal sphere, this process is normally undertaken by a jury. But in the civil sphere, with one exception, that being defamation cases, which can have a jury, most, and I'm talking 99.9% of civil matters, do not have a jury, and the judge is the arbiter of facts. Now, the other important part of the judge's role is to apply the law. Usually, in civil matters, the two sides will come with different legal arguments, and they will be arguing that the law ought to apply in a certain way, usually in a way which is beneficial to their particular side of the argument. The judge will look at these arguments and determine which of them is more legally correct and reach a result. Now, unlike determining the issues of fact, determining the issues of law and applying those is something which is capable of being appealed. It's a really important thing to note that when you go to court in the original jurisdiction and the judge standing alone hears the matter, determines the facts and determines the law, the latter, the legal aspects, can be appealed, whereas the issues of fact usually cannot. In the common law system that operates in Australia, judges do make law. However, they are not free to just pick and choose whatever law they feel is applicable for any particular given set of facts. Judge-made law follows these long-established and carefully mapped out rules of precedent. Now, these rules of precedent, or the doctrine of precedent, which is known as stare decisis, in its simplest sense, states that where the facts are materially similar, a judge in an inferior court is bound to follow decisions of earlier, higher courts. So, in the Queensland context, a judge in the Queensland Supreme Court is, again, when the facts are materially similar to a matter which has been heard in the Queensland court system prior and been appealed to the Queensland Court of Appeal, is bound to follow that judge's decision. And the Queensland Court of Appeal are bound to follow earlier Court of Appeal rulings as well. It's important to note, and this is where things can get a little complex, that when a judge makes a decision, only the reasons for that decision are binding on subsequent inferior courts. The reasons for the decision, which are known as the ratio decidendi, are the legal rules and principles that a judge uses and applies to the facts in that situation to make the final decision in that particular case. These ratio decidendi, or reasons for decision, are mapped out statements proclaiming what the law is, and they essentially form the reasons for a judge making a particular decision. A judge can, however, as part of the process of reaching a particular decision, have multiple reasons, each of which point to the particular result that judge comes to in that decision. Now, this is complex. It is something that is not widely understood and really clearly explainable. Even judges and lawyers themselves can have a hard time interpreting the cases that judges have, or judgments that have been made, to try and determine exactly what the ratio is. And this is made even more complex where there are multiple judges hearing a matter, usually on appeal, and those judges come to the same conclusion but use slightly different phrasing. And it's a difficult thing because when a judge, trying to make a decision where the facts are materially similar to a similar case that's gone to one of these appellate courts, where the judges have said similar but not identical things and came to the same conclusion, the judge in the inferior court has to carefully go through and determine what that ratio is in order to determine which aspect of that is binding. And where there are multiple judges in the decision, it's the judges of the majority that count. So, for example, a High Court decision which is split, where 4 judges conclude one way and 3 conclude another, the reasoning of the 4 in the majority form the ratio. And this can be even more complex, where those 4 judges explain things in 4 different ways, whereas the minority, in some situations, the minority 3 can explain it in one way. This can be very, very challenging for a judge in an inferior court to try and determine what the ratio is, and, in terms of the case in front of him, what the subsequent decision they have to make is going to be. Statutory interpretation is a big part of legal practice. Now, in relation to our court system, judges are confronted with statutory rules in almost all decisions that they make. Now, most of the time, when 2 parties are sufficiently emboldened to go to court, they do so because they don't agree about what the underlying law is. Rational people who know that they're going to lose don't usually go to court to argue the point. Now, this process of statutory interpretation is both challenging, and it is an area that judges find, in terms of how they interpret stuff, that is one of the areas that is often the basis of appeals, and that the way the judge goes about interpreting a particular statutory rule, the losing side in a dispute often has or believes that there's some form of defect in it, and that's the reason why these things go on appeal. So the process of doing the statutory interpretation is manifold, and we're going to go through each of these areas, starting with the first and most basic aspect. It was just to read the statute, and not just to read the particular section which is in issue, but also other aspects of it. We're also going to talk about the syntactical presumptions. These are particular common law rules which have been developed by judges for the interpretation of statutes. We're going to look at the Acts Interpretations Act. We're going to talk briefly about how judges interpret earlier cases in terms of making their decision. I'll briefly talk about extrinsic material, so things outside the statute that can be brought in to aid in the interpretation, and some of the less used common law interpretive rules that judges can and do use, where there are still defects in determining what the meaning of the statute is. The first and kind of the most obvious way to go about doing statutory interpretation is just to read the statute. However, when reading contemporary legislation, it's quite common for words to be defined in other parts of that statute. Sometimes in a definition section. Again, most contemporary statutes have a separate section or schedule at the end of the Act where the words that are used throughout the entire piece of legislation are defined. It's also not uncommon, though, for particular words to have, for a part or chapter, or even for a particular section, another definition which is to be used only for that chapter, part, or section. Now, from time to time, these things can sometimes be in conflict. For in other words, there may be a definition of one word that's in the definition section, but in a particular part or chapter or section, there may be another definition of that particular word, or that word is broadened in definition. In other words, the particular term is defined again as being that word as well as a host of other things. For example, in the Acts Interpretation Act, the word person means a person as well as a body corporate. Now, the definitions that are included in sections and included in parts and included in chapters are confined to those particular parts or sections or chapters. And the reason for that is that the parliamentary drafters intended it to be that way. Legislation, you'll recall, is really almost an enshrining of the will of Parliament. It's what Parliament wanted and Parliament intended. And so these statutory definitions that are included in the statute are done for those specific reasons and purposes. Now, fundamentally, when statutes are drafted, since about the 1970s, there's been a really concerted effort to try and make legislation as plain and clear as possible so that citizens can find the appropriate piece of legislation, open it up, read it, and know what the law is. However, there are some additional interpretive mechanisms that courts have developed over a long time that unfortunately do modify what the plain English or ordinary meaning of particular words and phrases might be. The first of these is the adjustum generis. This is where a list of items is succeeded or followed by an open-ended class. For example, weapon includes sword, knife, blade, or any similar thing. Now, what that means, what the statutory interpretation rule means, is that this open-ended class, any similar thing, is actually restricted by the list of items that comes before it. In this case, a collection of metal-bladed objects. And so that when we're trying to determine whether the particular thing we're analysing, in this case a firearm, falls under that open-ended category, the answer would be no. The second of these syntactic presumptions is the Nositir Socis rule, or commonly referred to as words of a feather flock together. Now, the way that this can be described is that when, again, there is a group of words or terms together, if one of them is unclear or ambiguous in some way, it takes its meaning or draws its meaning from the context of the other words in and around it. And the classic case of this comes from 1827, the case of Anne Harris, where the accused was charged with wounding, or the Crown was trying to argue that this fell under wounding, but the particular criminal section had to cut, stab, or wound another person. Now, in that particular case, the accused had bit the end of the nose off the person, and the argument was, well, does this count as wounding? And when trying to determine what the word wounding is, well, really, in that context, wounding is meaning sort of breaking the true skin, cutting or stabbing. That the word wound in that context takes its meaning or draws its meaning from the other words that surround it. The third statutory presumption is the expression unius est exclusio alteris. This exclusio rule is basically a presumption that, look, if Parliament went and put an express provision into a statute, for example, if they put an express provision into one of the social security pieces of legislation that's allowed a particular class of visa holder to have a particular benefit, then the express inclusion of this implicitly excludes the things that weren't mentioned in the statute. Parliament, in enshrining particular rules doing certain things, implicitly excludes other things. Now, this fourth syntactic presumption is where you've got two statutes, an early one and a later one, and they're in conflict. So some provisions in the later statute conflict with the early one, and Parliament hasn't clearly mapped out which of these should be in effect. The legis posterius prioris contrarius abrogant rule, or the legis rule, states that the later statute will impliedly repeal the earlier statute to the extent of the inconsistency. Now, essentially what that means is that if Parliament passes a new law and it doesn't map out how it impacts or affects old laws, by default, the courts ought to assume that Parliament intended this to overwrite or trump the existing framework that was in place up to and before, including the time when this legislation is brought into effect. And as an exception to the legis rule, this generalia specialibus non derogant rule states that while legis is the general rule, where there is a conflict between a general piece of legislation and a very, very specific piece of legislation, then the specific things will trump the general ones, again, to the extent of this inconsistency. So, for example, a statute which in broad terms protects all wildlife in Queensland would be a general statute or a general operation in effect, whereas a specific piece of legislation that specifically allowed for the extermination of cane toads within a certain radius of a certain city in North Queensland would be a specific section. And in that case, assuming that the two are in conflict, then the general statute protecting wildlife generally will be impliedly repealed in regards to this specific statute. An important piece of legislation in both the Queensland and in the federal system are these Acts Interpretation Act. The Parliament of Australia and of Queensland have from time to time needed to map out and tell the courts how to go about interpreting statutes. And it's important to note when you are reading a statute that these exist because there are certain definitions that are included in the Acts Interpretation Act that a lot of people may not be aware of. For example, where particular phrases and terms are used, gender, number, the word person, on references to time. Where these come up in statutes, these already have meanings that have been modified by statute and in this particular place. For example, wherever there is a reference to he, unless such reference is very specifically phrased, deliberately mean a man as opposed to a woman, where it says he will actually be interpreted by the courts to read she or he. Where singular and plural are used, they are interchangeable. And in terms of legal personality, and this is a pretty important rule, where a statute uses the word person, the Acts Interpretation Act in both Commonwealth and in Queensland stipulate that person, by default, includes bodies corporate. What does that mean? It includes companies, it includes incorporated societies, and it includes building body corporates and other similar statutory bodies. That's a really important rule because, again, if the context is one where it can only refer to a natural person, then that definition is to be preferred. But by default, it will include companies and incorporated societies. Finally, when there's a reference to time, and this comes up a lot as well in terms of the number of days that a specific series of events need to be carried out by, then they generally, unless clearly mapped out or there's clearly expressed instruction to the contrary, will exclude the day that the particular event occurred. So, for example, if something says that a person has 3 business days to respond, that generally doesn't count the day in which the event occurred. So, for example, a statute might say that a person has 28 days to appeal a matter, or 28 business days. That generally will not include the day in which that time starts to run on, for example, when the judgment is first issued. Now, it also operates to extend time where, again, this use of business day falls on either a statutory holiday or a weekend. So it's important to note, particularly when reading statutes for yourself, these particular rules need to be read at the same time that you read the main statute. It seems quite straightforward to say, when reading a statute, that you look at the words that are contained within that statute. However, where there is some form of ambiguity, the courts can go and look at other material in order to resolve that ambiguity. Now, the courts is not obliged to do this. And again, we have section 15 capital A, capital B of the Federal Act that says consideration may be given to material not forming part of the Act to assist in trying to ascertain the meaning of a particular provision. And the second subsection lists the type of material that the courts may consider, and they include such things as the Hansard speeches, which is the record of parliamentary speeches made. They can look at the relevant treaty or similar document, if there's an international instrument that a piece of legislation in the federal context has been drafted in reliance upon. And it can also look at other things such as royal commissions and parliamentary committees as part of this interpretive process. Important to note, the courts do not have to refer to this extrinsic material. It's not an error of law not to, but it is commonly performed where such things do aid in the underlying interpretation of a particular provision. One instrument that the courts don't often refer to are dictionaries. Now, the courts can use dictionaries, and it's not uncommon as a starting point for a court when we are trying to resolve ambiguity in a particular word to start with definitions that have come from other cases. That's the sort of the best source to start with, assuming that the meaning from the statute is either not defined or not clear. Now, the courts have developed rules in terms of how dictionaries are to be used, and the key part here is that dictionaries can only be used to confirm the ordinary meaning of a particular term. It's not the place that judges go to find a particular definition and then insert that as the definition to use at law. It's an important consideration, because otherwise we would have this kind of quirky situation where the definitions would come from dictionary makers and not from Parliament and not from judges. So it's something that it does come up from time to time, but it's not often that judges do go through and draw from dictionaries to get words. Also to note that judges sort of flip-flop around in terms of which dictionaries to be preferred. The High Court have generally preferred the Macquarie Dictionary, which is Australian English, but certainly you will see from time to time in courts the Oxford being used as well. When judges are reading statutes, they are obliged, thanks to the carefully mapped out rules in the Acts Interpretations Act, to interpret that particular provision in line with the underlying purpose of that legislation. Now, the courts up until relatively recently have used a variety of methods in terms of statutory interpretation, such as the literal rule, the golden rule, and the mischief rule. But fundamentally, these have been essentially superseded in that Parliament has stepped in and said, we want you guys to follow as best as you can what we intend a particular statute to be for. What does that mean? It means that the purpose of an act, which again can be ascertained by referring to such things as these secondary extrinsic materials, the readings of in Parliament, speeches of the Minister, parliamentary commissions, and so on. And where there is this ambiguity, the courts are obliged to resolve that in order to achieve the particular underlying purpose of what that statute was for. A really important part of contemporary legal practice is trying to get clients to resolve disputes without going to court. Courts are stressful, courts are expensive, the cost of litigation is huge, it can take a long time, and in most disputes there's only going to be one winner and one loser. And in fact, in some situations, both parties can lose, where matters go on beyond a certain length of time, or defendants go broke. Now, there are a variety of mechanisms that people use to try and resolve their disputes, and the most simple and straightforward is simple negotiation. This is where there are two parties or more parties to a dispute, and they either get around a table or they shuttle information backwards and forwards between each other to try and negotiate a settlement, which, again, in most situations can then be lodged in the court without the need for things to go to trial. However, negotiation, if we kind of think about it, is the process that you would do if there was a way for the parties to go and resolve their disputes without resorting to courts. But often the whole reason that parties are going to court is because they quite reasonably think that their position is the correct one and the other party is wrong. Now, in the list of alternate dispute resolution item or ADR items that we have there, negotiated, then mediation, expert appraisal, and so on, these become more formal and structured and expensive as we go further down the list. So mediation, for example, is just a bit like negotiating, except you have an impartial third person there to guide the process. And the role of the mediator is to try and map out some sort of middle ground that the parties can agree on in order to try and smooth things over and reach a form of resolution. A more structured way of doing that is for each side to produce their case and give it to an expert. The two sides usually agree to pay or fund an expert to look over the two cases and determine who's going to win and who's going to lose. In certain industries, there are structured mechanisms for trying to resolve disputes before they go to courts. Now, for example, there are employee and employer dispute mechanisms run through the Fair Work Commission. Now, if, again, and this happens in situations where parties are both pretty sure of their respective arguments, the parties can either submit to, or may be forced to, through statutes, to go to what's called arbitration. That is kind of like a court. Arbitration is a structured, systematic mechanism where the parties go, present their case to an impartial but still very technically competent arbiter. And again, this can happen in large-scale industrial disputes, and where there are types of industries where there are a lot of people. For example, arbitration for unions when dealing with or representing a large number of people on their behalf. These things can go off and be heard in front of this structured person in place to try and determine which case is going to be stronger. Now, in some situations, it's a requirement before you go to court that things are to go to arbitration. Occasionally, these things, because they're forced upon both parties, the arbitration process, it can be sometimes a little bit pointless and just adds to more expense for both of the parties. But in some situations also, the result of the arbitration, particularly if it's damning one way or the other, can be adduced before the court if matters do go or are referred to the courts in future. So while we only spend essentially one slide talking about ADR, it is a really important component, and in contemporary business practice, it's something that should always be foremost in your mind when trying to resolve a dispute, to actually go through and at least think about these processes before lodging matters in the court. It can save everyone a lot of time, stress, and angst, and in particular in situations where you feel that you have a strong case and the other side feels that they have a strong case. You may want to try and resolve disputes just to hedge your bets. So I hope that this overview of the Australian court structure and system has been useful, and that you do think about some of the mechanical aspects of this in terms of how judges go about doing things and courts go about resolving disputes, and these mechanisms for trying to avoid the court system altogether.